Now, from a university lecturer, let's go to Paul Vale lawyers, a criminal defense lawyer.
Yes.
What would you do? How would you start that process in your practice?
Well, we would obviously ask the defendant or the accused to tell their story. And if you look at their story and you think there's still issues, you look at the second part you look at is obviously the evidence that's being presented by the prosecution. Sometimes you don't want to hear the defence's story, you just want to have a look at the prosecution case. And then from the prosecution case, you can determine which theory you're going to go for. And then once you develop that theory, then you start going into the questioning, how you would ask the questions and how you prepare for the questions to be asked. So it's a step-by-step process, Dinesh.
And Dinesh, I guess as you go through the process, you'll recognise disputes about admissibility of evidence, whether that be evidence that you already have or evidence that might come up in court, and the strengths and weaknesses of the opponent's case and yours.
To conduct any case, whether it's strong or weak, without such a theory or a strategy is less than professional. Now let's go more into the examination techniques. As lawyers we use certain words, but let's get an idea. So what is an orientation question? Can someone explain?
What is your full name?
Dinesh Weerakkody.
And where do you work?
4 Burwood Highway, Burwood.
And what is your occupation?
Legal practitioner.
Were you at the Burwood Tavern on the 15th of August 2015 when a shooting took place?
I was. I go there quite often. Notice how the witness was invited to state his full name, his occupation, give a little bit of a background. That puts the witness in a situation where he can relax and also introduce the witness to the court. So this will leave the witness for the second stage to answer in a sort of a parrot style. Let's role play.
I'll ask the question, shall I?
Yeah.
Mr. Weerakkody, where do you work?
At 4 Burwood Highway, Burwood.
Right. And does anyone else work with you?
Yes.
Who's that?
Other lawyers.
Okay. Do you work anywhere else outside of that workplace?
I do, yes.
Yes, where is that?
I go to courts.
I think from those questions, the witness is probably going to be regarded by the court as a steady, well-educated and reliable citizen with a stable background, and he has a responsible job where his honesty is essential.
Thank you, Emily. Now, let's talk about leading questions, because some are afraid, especially recent or new practitioners. So what is a leading question and why is it not allowed?
Well, Dinesh, a leading question is essentially when you say something and you lead, as the type of question suggests, you lead the witness to answer in a certain way. And
kind of like hoping for an answer.
Yeah, kind of hoping for an answer. Yeah, that's correct.
Why is it not allowed? Anyone?
Well, it is allowed in cross-examination, but not in examination in chief.
Right.
In other words, it's not allowed when you're asking your own witness questions. Although we're always hoping for a particular answer, but you're not allowed to essentially put words in your own witness's mouth, because you could essentially tell their entire story for them and then have them just say yes at the end.
Right,
Now,
that's the underlying rationale at the examination in chief stage.
Yeah, that's right. So when you are trying to get the story out of your client in the examination in chief aspect, that's when leading questions are not allowed. In cross-examination, some people say you should only ask leading questions.
I see. Right. So let's move on. So what's the foundation question and why is it important?
Well, what might be called a foundation question is it's essentially a question that establishes where, say, for example, an exhibit came from. So you can't lead with an exhibit in the sense that you can't just present an exhibit to the court and expect them to accept it. You can't present a couple of photos or a drug lab analysis or a murder weapon to the court and just say, this is the murder weapon that was found. Because, frankly, anyone could have just taken that murder weapon and anyone could have just taken any old drug analysis. There has to be some proof about what's called the provenance, or really the origin of that exhibit, or what's sometimes called proof of the chain of custody. So sometimes you will find very detailed, exceedingly detailed statements from the police who say, well, I found this murder weapon at the scene and I packed it up in a plastic container and then I handed it to this police officer, and that police officer will have a statement that says, I took it to the lab, and there will be proof of the entire chain of custody that proves exactly where that particular item came from all the way to the courtroom.
Could you even go so far as saying that if a police officer found the murder weapon, say in the forest, that they had seen footprints leading up to that murder weapon, so then it also kind of leads into the chain of events of finding that weapon?
Well, they certainly could give evidence about that, certainly, and if they took photos of that, then they would give evidence that they took the photos, and if they handed that photo to someone or put it in a locker, or that next person would also give evidence that they took custody of the locker. So it's important to...
And the reason behind these chain of questions and these chain of events and all these statements is because the security of certain pieces of evidence is paramount to a trial. For example, if you have a gun and the foundation issue or the main issue is whether that gun was shot by A or B, that the non-contamination of that gun is central to the case. And if you don't have that chain of custody of the weapons, it can be contaminated.